Hi everyone, today is day 2 of our agent training, and today we're going to talk about fair housing and advertising, and then the second half of this afternoon we are going to talk about rentals. So fair housing defined, all home seekers shall have the opportunity to buy or rent any home in any neighborhood of their choice, subject only to whether the home is within their financial capabilities. Primary Massachusetts civil rights laws prohibit all discrimination in sale or rental of all residential and commercial real property. Virtually all residential land, housing accommodations, commercial space, and all land intended to be put to commercial use in the Commonwealth are covered by this law. So now we'll go over the protected classes and what is a protected class under federal law first.
Sure. Where this one? Okay, so federal law, 7 protected classes. Race, color, national origin, religion, sex or gender, familial status, and disability.
So that's the 7 protected classes under federal law. Massachusetts law also adds 8 additional protected classes. So it's almost like double protection. The 8 additional protected classes are age, ancestry, children, genetic information, marital status, public and or rental assistance, sexual orientation, veteran, military status, and gender identity, which was added in 2012. Are there any of these titles that anybody doesn't understand or wants explained?
So there's federal housing law exempt and non-exempt. Exemptions from fair housing laws do exist, but many differ from federal law states. So a broker or salesperson, not exempt, allowed if license involved. And then the age protected class in Massachusetts. Inquiry of an age illegal, permissible to determine if an individual has reached age majority.
So you're not allowed to ask about age. That's interesting when it comes to, for instance, senior housing, which has many different rules, as you know. Sometimes it'll say both people have to be 55 or 60. Some places will say only one person has to be 55.
Yeah, it gets a little difficult.
Yeah. Approved senior housing exemption is exempt. And minor or person not reaching the age of majority exempt. We'll talk about that more in the rentals, about if someone's 18, that they have to have a credit check done. Sorry, I'm segueing sideways there. Elderly or infirmed, Massachusetts law. Remember, we're going back and forth between what's federal and what's state. 3 dwelling units or less when one apartment occupied by elderly or infirmed person for whom the presence of children would constitute a hardship is exempt. That's an interesting one. All right, you want to do mortgage lenders?
So mortgage lenders, federal and Massachusetts law exemptions. One is inquiry of age to determine creditworthiness. Use of, number 2 is use of an, how do you say that word?
Empirically derived.
Credit system for which considers age. Credit life insurance and credit disability insurance to a limited age group. Refusal to grant any mortgage loan to a person under age of majority. And number 5, offering more favorable credit terms to specific age groups.
So interesting. Number 1, I think, refers to a mortgage lender saying, oh, you're 60 years old, so I'm not giving you a mortgage because who knows if you're going to have 30 years left to pay it off or something like that. You know, you can't do that. For very many reasons. First of all, is the age. I mean, you just have to be very careful. And when the mortgage lenders go for their licenses and their continuing credits, you know, they're taught about all of this as well.
They're pretty strict with that kind of stuff too. So,
owner-occupied residential. Number 1, leasing dwelling units in owner-occupied building of 4 dwelling units or less are exempt under federal law. Massachusetts limits maximum exemption to single dwelling unit in an owner-occupied 2-family house. So the difference is owner-occupied.
So if you have a 2-family and you live there, you have the right to choose who you allow to live with you, since you live in the house with them.
Interesting. Never exempted. This is a list of never exempted from fair housing laws by race, recipient of rental or public assistance. What are we talking about? Chapter 11? Is that what it is? Is that what it is? Chapter 11? The public assistance is Section 8, I'm sorry.
Section 8.
Why do we say that wrong? And the refusal to rent to a family with a young child due to the presence of lead paint. We talked about that in detail yesterday. You know, the thing about this, and we talked about this yesterday too, is so many times you're learning by coming to this class, but so many times you're taking this knowledge and trying to educate your seller on what's right and wrong. Now you've got to add to that what the federal and state fair housing laws are. And, you know, they could be like, I have no idea what you're talking about. Yeah. But you know you're right from wrong.
And you could be liable if they're not listening to you guys and what you guys are telling them what to do and what's right and what's wrong. You're the one that has the license, so you're on the hook for it if they do something on your behalf.
So under Massachusetts law, a single dwelling unit temporary leasing not to exceed 1 year by owner of principal residence. I think that reminds me of some of the Cape Cod laws, which have to do with rentals. Maybe we can talk about that later too, because I know it's a little different down there when they're doing the short-term seasonal rentals. And the last one on that page?
Substance abuse exemption. Massachusetts and federal laws recognize recovery from substance abuse as a disability. So that one's tough.
That is, yep. Federal law, additional exemptions not protected by fair housing law. Current users of illegal drugs. These are not protected by fair housing laws. We're on page 3.
So you don't need to be okay with them. You can kick them out.
Of course, how do you know if they're current users of illegal drugs?
Yeah, that's
Persons posing threat to the health and safety of other. Again, that's kind of subjective, I guess. How do you know that? I mean, if you've had to call the police on them, I suppose. I don't know. And the third one is illegal, undocumented aliens. I guess that would be part of the
something else
screening process, right?
As well.
You guys okay on the pages there?
We are not. Thank you.
Okay. Prohibited discriminatory practices. First, protected classes. Refusal to sell, rent, or deny housing to anyone included in a protected class. Blockbusting. That's federal and Massachusetts law. So more of what to be very careful of. Second one goes into what we talked about yesterday with lead paint. Children and lead paint. Federal and Massachusetts law. Just that you cannot discriminate against children on the basis of existence of lead paint. Housing discrimination against persons with children prohibits discrimination in leasing or renting of accommodations to any person because the person has a child or child who shall occupy the premises with such person, except the exemption of owner-occupied, right?
Yeah.
You want to do 3?
Definition of children. Number 1, any individual who has not yet attained the age of 18. Discrimination against persons with children extends to pregnant women. So they can move in and all of a sudden they're pregnant. You can't have lead paint there. That baby is going to be under the age of 6. discrimination against persons with children shall extend to persons who are in the process of securing legal custody of a child or children. And then illegal actions, federal and Massachusetts laws. Number 1, refusing to rent or sell or negotiate housing, representing a dwelling as unavailable when it actually is available, providing different lease or sale terms or privileges to different people, setting different conditions or privileges for sale or rental of a property, denying access to or membership in a facility or service related to the sale or rental of housing, imposing different rates or terms on a loan, refusing to make a mortgage loan, discrimination in appraising property, making discriminating inquiries, retaliation as a consequence of employing or claiming a protected right, discrimination of a prospective tenant based upon public or rental assistance.
Oh, before we turn the page, let's go back to number 2, representing a dwelling as unavailable when it actually is available. So again, you're the licensed person, and your seller, you could tell that the seller is not treating someone fairly or is saying,
It's off the market, but it really isn't.
You've got to be very careful to protect yourself. And in essence, if the seller continually is not going along with fair housing laws, it's better to walk away from the deal than to be involved in a deal where the seller is doing things that could get both of you in trouble later on.
And that client's going to call you because you're the licensee.
Yeah.
So they're going to call your broker and they're going to complain against you.
And the same aspect with number 4, setting different conditions or privileges for the sale or rental of property. And the seller may be, not suggestive, that's not the word, but he may be using different terms for different people just because he wants them to be the one. You can't do that. You just cannot do that. And the tenant will pick up on that, prospective tenant. So you've got to cover yourself, which is why we're going over all this. Number 12 is sexual harassment. Number 13 is discrimination in advertising. Obviously, you cannot discriminate at all in any advertising. Making notations indicating discriminatory preferences. Coercion, intimidation, interference with any party in exercise of their rights. And 16 is inquiries, federal and mass law. So it's a lot to think about, but I think, again, so many times you're educating the seller on what's right and wrong to do, so you have to be careful about that.
Inquiries whether a person is included in a protected class, questions that indirectly or innocently elect whether an applicant is included in a protected class. So D, memberships, that's federal and Massachusetts law. Denying access to membership or participation in multiple listing service or any trade organization based on a protected class. Redlining, steering, discrimination in contracts, uniform behavior and procedures. A landlord, rental agent, or any licensee is advised to treat all prospective tenants, customers, and clients the same. So if someone calls you and they ask you a question and you say it's not available or it is available, and then somebody else calls you and you say something differently, that could be bad. And they do test you, so make sure you're always saying the right thing.
So because they mentioned the word steering, let's turn to page 9 of your manual. I found this great article. It's called Steering Schools and Equal Professional Service. And this is, remember when you're writing your written descriptions in MLS PIN, remember all of your fair housing laws. So it says, what is steering? Steering under the Fair Housing Act is the process of influencing a buyer's choice of communities based upon the buyer's race, color, religion, gender, disability, familial status, or national origin. Steering on the basis of any of the characteristics defined under the Fair Housing Act is not only unethical, it's illegal because it limits the housing opportunities available to that buyer. Steering occurs when an agent limits the housing options available to a buyer by directing prospective home buyers interested in equivalent properties to a different neighborhood or community, or even parts of the same development according to the buyer's race or other characteristics. One way of directing, that means steering, can occur is through comments by an agent, either positive or negative. See, remember, you just have to be so neutral. For example, if an agent limits or does not provide housing options to a buyer in a community because of the community's racial composition, the agent may effectively be making housing unavailable. Or if an agent expresses his or her own personal positive or negative views about certain communities, the purpose of which is to direct the buyer either towards or away from a community, that's steering as well. These would be violations of the Fair Housing Act and of the Realtors Code of Ethics. So that's really important. I will give you an example. I had a condo in Winchester a couple of years ago, and on the first open house, I had like 20 sets of people come in, and a young Chinese family came in, and they said, "Can you tell me if there are any Chinese families in the neighborhood?" At that moment, you just go silent. So your response has to be,
I don't know.
I can't answer that,
Tour the neighborhood at different times.
I mean,
to
I've
see.
seen people sit, outside watching kids playing on the weekend in a neighborhood or whatever it is, but boy, you never want to touch that question.
Yeah.
Never.
I usually just tell them, come by different times a day, check out the neighborhood for yourself. I don't know the answer to it. I don't want to get in trouble.
And again, about if we ever have MLS PIN classes, we had a couple of those last month, about your written description. Boy, the fair housing, all of these terms that we're talking about come into play, and you have to be so careful. We're going to go over acceptable words in a minute, but you have to be so careful as to what you say and don't say so that you're not saying anything that's limiting to that. The things that are not included in any protected class are illegal drug use, again, how would you know? Registered sex offenders, I have to speak to that one too. I actually had a state trooper as a client a few years ago, and he started to ask me that. Again, you're not giving that information. You just say, there are state websites if you want to look that up, and of course he had the access to do that.
Yeah. And you can provide those websites for them. Like, here you go, do your own research.
I keep them on my sheet.
Yeah.
That's a good idea. Good idea. Smokers, smoking, students, animals, service animals. We're going to talk about that.
That's becoming
Later.
a big thing now.
Yeah. What is a service animal? What isn't? What questions can you ask and not ask? Handicapped, disabled circumstances. The inquiry whether the individual has a physical or mental disability prohibited from being asked. Landlord should never attempt to assess the disabled person's capabilities. That's really judgmental, subjective, whatever.
What if you had someone who was clearly disabled and you asked them, and you like them, you wanted to rent to them, and you said to them, is there anything I can do to help you when you're in the house? Like you could suggest.
Like modifying the house?
Yes.
Yes.
Is that something okay or no? Because then
Well,
someone could be insulted by that.
Yeah, I mean, actually, that's the positive side of it, and I would say it's a shame if they get insulted, but on the opposite end of it, there are landlords who don't want to do any modifications.
right.
That's another thing.
Right.
You go to the point of modifying it, and then they're there only a year, and then they leave. But I think the modifications are something that you do have to do if they have the handicap.
I mean, if you guys were already in agreement, I would assume that would be okay. But maybe ask Joe.
I suppose you could say, if you need anything, maybe I can help you, or just ask, or whatever.
They
If
may
you were
Keep it broad.
landlord,
Yeah.
right, yeah, I guess so. Well, I'm not.
Sam?
gonna do
I
it.
thought for modifications, I think you can do them out of pocket. They can't deny you doing modifications, but they're not responsible for the cost of modifying to adapt
Right.
to you or
Right,
something.
right.
Yeah,
I-
but she's
as far as
asking
I
if
know.
if
No,
we
I
can
meant
even
if
ask
it
that.
would be an
Oh, okay.
insult or some,
But you may have the tenant ask, in reverse, they may ask you, would you do a modification for me? And that would be different.
Right.
But you're saying that by the landlord asking that, it might be showing discrimination or being
Well-
insensitive to the disability.
Yeah. I
Or
mean,
opening yourself up
Yes.
would be my bigger concern.
Yeah.
Again,
Because-
going back to referrals possibly. So that's,
Yeah.
Yeah, I would just be very careful. They'll usually tell you,
Yeah, they're
if they
pretty-
have,
They need something up front, they'll usually tell you.
or if the state is giving them funding to help with the modification or something like that. New construction, all residential new construction, 3 or more dwelling units, so multifamilies. 10% of dwelling units maximum for which an owner shall be required to provide disabled accessibility to new construction. Interesting, 10%. Public areas accessible and usable by handicapped persons. Doorways sufficiently wide for wheelchairs. All dwelling units must contain accessible route into and through dwelling unit, light switches, outlets, thermostats, environmental controls at an accessible location. Reinforcements in bathroom walls to allow for grab bars, and usable kitchens and bathrooms so wheelchairs can maneuver. So the new construction, the codes for new construction are very strict, and any builder or general contractor is aware of all of these things being added to what it has to be included in new construction.
Reasonable accommodations and modifications in existing dwelling units. Landlord required to allow or make reasonable modifications. So if it's something like crazy, widen up the doors, you know what I mean? Like it could be a little pricey. Landlord required to make reasonable accommodations in rules, policy, procedures, practices, or services. Property owner shall not establish or impose additional rent or other charges for the handicap accessible housing, and landlord cannot refuse renting to disabled persons because of the special needs. Interactive process, landlord must engage interactive process with disabled prospective tenant. Service animals,
Here we go.
signal dogs, service animals, seeing eye dogs, or other animal individually or specifically trained to provide assistance to the disabled cannot be excluded from any housing or any public place.
So part of your handout, we're going to go over this in a minute, but this was the rental class that we took at the NEAR board, and the only reason you all have this, and I'll put this online for everybody, but in here, he talked about what service animals were and what you're allowed to ask and not ask. Here it says, you cannot ask for proof of a service dog, but you can if for emotional support. Got that? So listen to that again. You cannot ask for proof of a service dog, but you can if for emotional support. And in the American Disabilities Act, it can be a dog or a miniature horse. Seriously, guys. Alcoholism is considered a disability.
So,
Okay, go ahead.
so for 55 plus communities where they sometimes allow disabled individuals to live in there, exempting as an exception to the rule,
Right.
something like this would fall. So if you're having a drink a day, essentially you're considered an alcoholic, and you could get away with either potentially suing someone, right, because of their liability. Most people are going to violate something like this very easily, whether they know it or not.
My question on that statement would be, not what you said, but what's written here is, who's proving what's alcoholism?
Yeah.
Is he a social drinker, or is he going to rehab and been diagnosed with alcoholism?
Yeah.
And does he have to prove that to the landlord?
Yeah, that's the thing. Does that person have to prove that, just because someone's an alcoholic doesn't mean they're getting support?
Yeah.
Yeah, well, that's for
So,
sure.
There's no proof, essentially. There's no proof to prove alcoholism in a way, unless it's been treated.
Yeah.
you know,
True.
but-
The other thing I was going to mention, and I thought you were going to go on the 55 and older. I know of a subdivision in North Chelmsford. I think they will take one tiny dog. You can't be over 25 pounds, and it has to be interviewed. Let's say that that's the rules. So if you have a service animal that's a black lab, that would be an exemption because it's a service
You
dog.
can't do it.
Right. So it's a lot to know. All right, now we're going to talk about advertising and marketing.
Am I going?
Sure.
Advertising and marketing. No exceptions to discriminatory practice in any type of advertising or marketing. Unlawful to make, print, publish, or cause to be made, printed, or published in any media, any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination because of a protected class. Determining violations in advertising or marketing, how an ordinary viewer would interpret it. Illegal words, phrases, symbols, and illustrations. Regulations prohibit use of any words, phrases, symbols, photographs, illustrations that convey dwellings are available or not available to a particular group of persons because of membership in any protected class. Human models in advertising may be viewed as discriminatory. Exclusive.
That's a good one, actually.
It's a big one,
That
too.
is a good one.
Exclusive use of young, old, white, black, athletic, non-handicap, single, Catholic, Jewish, or other ethnic or religious groups may violate the law. Selective media. The selective use of media catering to specific population within an area which may discriminate against another segment of the population is a violation of fair housing law. So, selective geographic advertisement, selective use of equal opportunity slogans or logo, selective use of human models. And that was a big thing on Facebook too, that whole selective area catering to where people are. That's a big one.
Notices and posters. Both federal and state law provide for posters and appropriate display whereof. We have that in all of our offices. The Massachusetts Fair Housing poster requires every real estate office and rental office that has public traffic to display this poster in a conspicuous place. The federal Fair Housing poster, HUD's written policy, a failure to display the federal Fair Housing poster shall be deemed prima facie evidence of a discriminatory housing practice. Interesting. Enforcement. HUD, Housing and Urban Development, is a federal agency responsible for enforcing fair housing laws. Massachusetts Commission Against Discrimination is a state agency whose mission is to enforce Massachusetts anti-discrimination laws in employment, housing, public accommodations, credit, mortgage lending, and education. Massachusetts is pioneer in anti-discrimination laws, as you can see by what we listed at the beginning. In the mid-1940s, Massachusetts established a commission to enforce laws prohibiting discrimination. In 1950, the commission's name changed to the Massachusetts Commission Against Discrimination, and its jurisdiction and power enforcement was widely expanded.
Law enforced by MCAD is empowered by statute to enforce the following anti-discrimination laws. Primary civil rights regarding discrimination, public accommodations, civil rights, sexual harassment, maternity leave, civil rights in education, and lead paint.
The complaints in Massachusetts. Any person, oh, this is the good part. Any person filing a complaint with MCAD for an alleged violation of Massachusetts anti-discriminatory laws must do so in writing within 300 days after the alleged employee-related action of discrimination and 12 months after the alleged housing-related act of discrimination. Civil penalties in addition to any other sanction not to exceed $10,000 for the first offense, $25,000 for the second offense within a 5-year period, and $50,000 for the third offense in a 7-year period.
You would hope you don't.
Jordan's having a stroke.
Just don't do it. Complaints in federal, so file complaint with HUD, civil, file civil action in U.S. District Court, administrative process, remedies, civil penalties, damages, actual or punitive, and injunctive relief.
So now the fun part. Turn to page 9. And I'll tell you ahead of time, this, if you read through this, this is what's going to cause you to be so super careful when you're writing your written description in MLS PIN. So I like the way they broke it down to what's acceptable, what you should be cautious about, and then what is unacceptable. If anything strikes you as really striking, just say it. For instance, we talked about walkability. Walkability is such a thing that people want to talk about now.
Yeah.
And why can't you say that?
Well, if you're disabled, I can't walk. And so many people are so defensive now.
Easy
they get
walk,
offended.
easy walk to commuter train. Would that be a good thing to put in your MLS listing?
No. Yeah.
So if you,
Easily
Close
wheelchair
proximity.
accessible.
You
gotta
could say
add
that.
everything.
Yeah.
You have to add everything.
Yeah.
I mean, they have these those walk meters, like the distance between, they have their rating of, well, this is walkable distance, whatever in the area. It's easy to get somebody
You're supposed
offended.
to have the flyers.
You can have that in your
Attached
marketing
bio
material. Yeah.
or-
Yeah. It's just in your description itself in MLS. You have
and
to be careful.
MLS does have 3 full-time people and 1 part-time person checking your written descriptions every single day.
And if you're in New Hampshire, they're way more strict than Massachusetts with the way you write your description.
So how many times have you seen in a written description, quiet, family-friendly neighborhood? That's terrible. What's a family? There's another question.
Whatever you make it.
Maybe a family is a grandmother and a grandson living together. You just can't do that. Who's to say it's quiet? I mean, maybe I lived near commuter railroad tracks when my kids were growing up. We didn't hear it after the first week. You just become numb to it. And we thought it was a nice, quiet neighborhood. Somebody else might look at that house and say, oh, I would never live near a railroad track. Yeah. So you can't make the judgment that it's quiet.
I'm looking at this one, same tenant only.
Same
Same
tenant,
tenant
oh yeah,
only.
same tenant only.
It's pretty funny.
It's about, really what it's about is making judgments on things that we have no right to make a judgment about. If you say couples only, I mean, what is a couple?
Who's the judge of that?
Two or more is a couple.
Yeah, that's a good way to put it.
And
Safe.
again, you have to protect yourself and try to educate your seller. I think a little bit of a more of a calm explanation is for elderly sellers. They've lived in their home for 40 years, and they don't understand how careful you want to be. And they see the written description that you've written. Well, why didn't you say da-da-da-da? And then you have to explain to them about the fair housing laws and say that you're not only protecting yourself, but protecting them by writing it carefully.
So I have a question here for the adult community. Wouldn't that be the 55 plus if it is a 55 plus? It's in the unacceptable section.
You could say 55 plus, I think I came across that.
You could say
advertising.
55 plus. I know that,
Because
go ahead.
if the facility itself actually requires license for one person, in that particular one
Yeah.
that we did. But I know we had to go through all this, and
So the same complex in Chelmsford that I knew the rules of, I knew a couple that was living there, and their daughter got a divorce, So of course she wanted to move back home with mom and dad with her 2 kids. The rule of that complex was that you could have a guest come stay, but for no longer than 30 days.
They all have different rules.
Yeah. Some of them have only one person needs to be 55. What if a 55-year-old person married a 40-year-old person? And if that was the rules of that complex, that would be okay. What if there was just one adult, one person that was 55 and a college-age kid that was 22? Again, it's, you just...
It's different per
Yeah.
division.
Yeah, so, use this, keep this list as a sounding board for when you're putting your written descriptions together, and make sure that you're protecting yourself and protecting your seller as well.
And it's not always just MLS that's looking out. It's sometimes other agents that are reporting you because you said something wrong.
I've seen so many, like Near Country Club, that I've seen in ads.
Yeah, you've seen all of these.
Yeah.
They're at one point or another.
You're not, now that you've been to this class, you're going to be more conscious of looking at what other people's written descriptions are and saying, ooh, I could poke holes in that one.
Yeah.
But it'll also help you to remember to do the right thing. I hate to say it, but fair housing, federal and state, is so protective that it almost leaves you like, okay, I need to be very generic and vague about what I write.
Yeah. Stick with the facts.
Yeah.
Yeah, shrink.
So another thing that really isn't the subject, but in MLS you cannot use the word new, only if it's the day it's installed. Otherwise it's updated, or you could put HVAC installed in 2015 or something like that. But that's another thing. You can't just say, oh, new everything when it was installed 5 years ago. Anyway. So that's a lot to think about. Again, Massachusetts is way ahead of the game with adding the additional protective classes to what the federal government already had. And good for us to be ahead of the game with that. It does make it a little bit more complicated, obviously, but we're protecting all of our clients by doing that. And it's gonna become more and more of an issue. Can you add the things that you can ask and cannot ask, especially with disabilities? You have to be very careful, very careful.
Could you put something for each, like say you said it was a great walking neighborhood, you couldn't,
Nope.
you couldn't say, and then have something for disabled? 'Cause then
To
you
counteract that, no.
can't do that.
You just can't put anything.
Yeah.
Wow.
Can't you just choose different language?
Well, like you said
Proximity
before,
to shops
you're right,
and
easy
trucks or
access
even-
to commuter train.
Yeah.
Doesn't refer to walking.
Yeah. You gotta be a little creative
Mm.
with the words that you use. That's all. The more you do it, the easier it gets.
So we're all set with fair housing, unless you have any more questions. And what we are going to do now is switch gears. Can we pause for a second or not? And did you pause? Oh, we're going to pause for a second, and Shawna is going to come on, and we're going to go over a lot, A to Z, thorough rentals, and all that's involved with rental documentation and leases and credit checks and everything. So we're just going to take a second to get set up for that.
Hi guys, we're back with Shawna, and she's going to cover our rental segment for this portion.
Thank you.
Welcome, Shawna.
Welcome to the second half of today's incredible class, Fair Housing. How many of you are fair housing advocates?
Everyone raise your hands.
Remember when we became realtors? When we got these little pens? The very first line is that we will provide housing. We will help all people find housing. And when it comes to all people, of course, we're all thinking in the back of our minds that we would like to be helping somebody such as a millionaire or somebody who has a lot of money. But then reality hits and you find out that only 1% of the world might have that kind of money, and the rest of us are the 99%. And those are the people that the laws are protecting, all 100%. And when it comes to rentals, you're going to put 100% of your time into fair housing advocation. What is the answer to, does the landlord accept Section 8?
Yes.
Yes, it's
Always
the
yes.
law. Yes, it's the law. Does the landlord accept a service dog? Yes, it's the law. Does the landlord make reasonable accommodations? Yes, it's the law. Does the landlord like children? Yes, it's the law. We just say, yes, it's the law. If you do that, you're going to be fine. If you say, I don't know, you're going to need two things. The first one is you need to go back for training. And the second thing is you need to hire a lawyer. None of us want to be there. Yes, it's the law. If we don't know what the law is, there are two ways to find out. One is to call a lawyer, and two is to send an email to Happy Agent and ask Happy Agent for help with your questions. There are lawyers that work for LAER and will answer your questions. Stacy Alcorn is also a lawyer. Never ever guess and never present a legal opinion on any fair housing, contractual, anything at all, anything that's on any of these papers that we're going to talk about today. If it's illegal, check the box on a contract that's being signed. That is a legal decision. None of us are attorneys. Some of the agents are attorneys, and that's a different story, but most of us are realtors. So lesson number one, if somebody says, can you give me your opinion about whether this is going to be good for me, or you think that the landlord will do this and it's a legal situation, just remind them, I'm not an attorney, I'm a realtor. I'm here to guide you through the process. I know some great people who can get us the answers to that. That's the best advice that I've gotten so far from my mentors when it comes to rentals. Never be alone in the room, up in a corner by yourself with a lot of people asking you questions and answering. When that happens to you and you're in a situation, pick up your cell phone and say, I need to make a quick call. Get out of that corner. You never want to be alone. Call Susan, call Stacy, call Happy Agent, call Kiki, call Lynn, call Sam, call everybody in this room. Definitely call Ernie. He will pick up every time.
And we have 2 attorneys on staff.
They are here to keep you informed, and they are lawyers, and what they say is what goes. That helps a lot. It takes the pressure off. The very first thing that's going to happen is most of us have leads that come in from OpCity or other lead companies. How many people use OpCity? How many of you have gotten phone calls from people from homeless shelters on OpCity?
Really?
5.
Wow.
How do we qualify a tenant client is a big question. In the real world of residential housing, you get a qualified buyer because they show up with a piece of paper that says, I've been pre-qualified for a mortgage. That gives them the ticket to start looking at open houses. You get together at the office and you go through all the documents together, and then you start to make arrangements for showings. Same thing for leasing clients, only we're not ever going to get that piece of paper. Gail's going to talk to us later about Zumper.com. That is the closest that we get to being able to qualify a tenant, because it will show what the credit history is, and if there's a background check, it will show whether the person has a certain history that might or might not be relevant for the housing that they're looking at. But our primary goal is to get as much information as possible, and we do that by using the rental application. The rental application will be fun for us to work our way through, because just like when we're working on an offer letter, a lot of what we put on a buyer application when we're first meeting with people goes straight onto the offer letter. So when you're working in .loop and you fill out the rental application, or you start to fill an offer, you can set it all up in .loop so that it autofills. Same thing, you just collect the same information, name, address, contact information. But on the rental application, we're going to go a little deeper. You have to watch out on these application forms for personal privacy information. In Massachusetts, we do not want to be responsible for personal private data, which includes birthdays, and it includes a combination of birthday, first name, and social security number. Anytime you see that, I usually do not have them fill out the social security on the fourth line down. The name of the applicant needs to be their legal name, and that's just as it is on an offer letter. You want to make sure that they sign the same name at the bottom of the page as what they put on the name at the top of the lease when we get to that. So make sure you get the legal name right up front. Email address and phone, basic contact information. The next thing down is how we start to find out whether this person has a history of having rented before. That is the best qualification that we're going to get in the beginning from the tenant client. And when they give us the name of their current landlord, then we will be able to call and do a reference. References are how we're going to find out whether this person is going to be able to afford the apartment. This is why if somebody calls you up right away and says, I have Section 8, will the landlord accept Section 8? Yes, it's the law. What happens if they have Section 8 but they have no other income? They don't work and they don't have any other money that they can bring to the table to pay for their utilities or to pay for the gas for their car or the food. Then what usually happens is that there's a second person who will arrive at some point in your conversation who is supporting and paying for all of these things. However, this is a problem because under the Section 8 lease, they cannot be listed. How do we present the income of a person that is not going to be on the lease? That is a very difficult situation. There's no answer to that other than if the landlord doesn't like that situation and doesn't accept the income from the other person who's not going to be on the lease, they probably won't accept that person. It's the landlord's decision, not our decision. We only collect the information. This is a common problem. You get down to this section of the employer, and there's no employer, and there's no income. You can put for income any money that they receive at all, anything at all. They'll tell you what that is. The next references that I always ask for are the personal references. That seems very old-fashioned, but in this day and age, being able to call up somebody and just ask a couple questions can make a huge difference for the tenant. You can present the person in a better perspective to the landlord. If somebody is volunteering for an organization, or if they have had medical or interesting personal history to present to the landlord. By medical, I was just thinking of somebody that I worked with who was working for a hospital and had become a nurse while they were a tenant in the property. But of course, we would never bring up any disabilities or medical issues or anything like that until after the application has been accepted. At that point in time, we can talk all we want about the disabilities and the accommodations that will be made. Any questions about how to get information out of the tenants in the very beginning? When you look at the bottom of this form, you're going to see a lot of language down here. Okay, so what happens when we find out that they do have a criminal history? We can't not show them the place because they're a protected class. They still get to see it. So why is it on this form? But it is on the form. We can't do anything about that until after an application is accepted. It's very confusing. They can reveal it, but you can't deny the application based on whether they're a convicted felon. You have to provide this document to the landlord when they make their decision. In Massachusetts, we can collect the 1 month's rent, the last month's rent, which cannot, and a security deposit. Security deposit cannot be more than 1 month's rent. It's good to let people know straight up front what they're going to have to bring for day one on a new lease. You can also get, I think it's $25 for a key and a lock, and that's it for what they can get. I always provide the new client with a copy of what's going to come. This is the pending rental file checklist, and they almost always say, this looks like a document that belongs to the company and I don't need this. But then I just say this is what we're going to cover and what's going to happen. You can use this as a guide as we go through all the documents together. The good thing about this list is that everything that's on here is handled by the Kofi for your team. You always have somebody who's backing you up with .loop and with all of the documents for leasing.
It's also reassuring because it shows them the things that you need to have signed to submit to the office.
In order to be in compliance
Yeah.
with the office, so that's good.
These are all available on .loop. If the application form is not available, you can add it yourself. Kiki, you're here today
Yes.
because you need a new apartment.
Okay.
Can you tell me a little bit about your
My situation?
Your situation. I need to know a few things such as, do you have any cars?
Yes. I have 2 cars. I have 3 children, and 2 of them are, one is 4 and one is 6.
Will there be any other adults living with you?
Yes, my boyfriend.
How far along are you in this housing search?
I need one yesterday.
Have you had any places that you've been interested in, or you've been?
I've seen a couple things, but I didn't get any callbacks, so still looking.
Do you know why they didn't call you back, or can you give me a list of places that haven't called you back?
Yep, I'll send you the list of places, but they just never called me back.
We'll start with those and see if we can get a response and see if we can get in to see some of those.
Okay.
Any place that you want to see, you just let me know, and I will do my absolute best to get you in there.
Okay, thank you.
Did we leave anything else out? Now we know cars. Oh, you know what we forgot? Are there
Pets?
anybody else in your household that you
have a
might be
cat.
bringing?
I have a cat. Are cats allowed?
Cats are, it's up to the landlord. We'll have to check on each and every property
Okay.
and see. We'll try, you can do some searches that have pet friendly, and sometimes it's a bit ambiguous on the MLS listing. You have to go through and see what you can find, but we can always make a phone call about the pets and see what happens.
Okay, sounds good.
Do you have any questions?
Sometimes they're not clear. They'll
No.
say,
Yeah.
Upon request, or
Yeah.
or you have to approve the animal first. So I'm like,
Yeah.
okay, meet my kitty.
Yeah.
Before they allow it in. So yeah.
One of the houses that I rented here in Marlborough, the owner is a dog trainer, and she interviewed all of the dogs. She loved all of
Really?
the dogs. She did not like any of the people.
That's funny.
Eventually she found a fit, but all the dogs were instantly accepted.
Yeah, I have done some rentals too, and pets is a big thing because if you are, I mean, it's up to the owner whether or not they want a pet. They're not a protected class, and a lot of people have pets or children. So it's like if you live there, you have the choice whether or not you want children in your home. But if you don't live there and it's investment property, you could only decide whether or not you want animals. And a lot of people don't want animals if they just re-renovated their entire property, and then you're going to let a dog that's, the size of me come in and ruin your entire house. So it depends on the owner too. So
And can you you had a tenant who had a pet that was not cleaning up your entire yard where your children were playing in.
I don't
So
remember.
if you don't have rules about how the tenant conducts their animal.
Yeah.
And you're living in the house,
Yeah, they need to clean up after themselves. You have to be very specific as to what the rules are when you're renting, especially if you're the landlord. You need to have guidance, and you need to have the right tenants in your property. Make sure, I mean, I know being a landlord is tough because you're getting all walks of life in your property. You don't know how exactly they live. They can have the most beautiful resume and application in the world, and then they're slobs in your house. So it's tough to figure out who to rent to, and you can't discriminate. So it's a gamble.
And there's another consideration to think about. Co-broke. On a housing, when you're doing a purchase, there's always a co-broke. The buyer's agent will get paid by the listing agent. When you take a look at rental listings, 80% of them have co-broke listed as 0, which means that the buyers have to pay for their agent, which means, when you think about it, it's a real obstacle for people to get fair housing, because it means that the buyer's agent has to only work for people who will pay their fair share, which is usually 1 month's rent split in half between 2 agents, which is a lot of money for a tenant. And especially, how is somebody on housing assistance going to come up with yet another month's rent on top of 2 months' rent already? This is a problem. The National Association of Realtors has made a big commitment this year. They brought in a new director for fair housing. I think his name is Michael Green. I'll look it up. He used to work for HUD in enforcement of fair housing for 29 years. This year, 2020, will mark a great year of looking at what's happening to prohibit fair housing for people. And rentals, that is a hot spot for us, because if an agent won't even offer a co-broke to another agent in order to get people in there, that's already a huge problem. And it's very demoralizing for the agents to go on and look and see a beautiful property that they would love to show to somebody, and you have 2 choices at that point. You can send your client on and have them take a look at it without you, and come back to you if they need your help, and let the listing agent do all of the work on the rental, which is basically what they're saying by saying they're not going to pay anybody else. Let them take it all the way through. Or you can work for free and not get anything out of it, or you can ask them to pay you. And that's a very tough place to be. And a lot of agents don't have the time to deal with that. When you're looking at a $300 co-broke, or sometimes it's a lot more, but generally it's somewhere between, I've seen $50 and I've seen half of it. So 50% co-broke of 1 month's rent. Commercial side's a little different. You're gonna have a different group of people looking for the commercial office space. They do expect to pay an agent if the listing doesn't already do it, but most of the time the commercial agents are paid by their client. Completely different world than residential leasing. It's a little bleak. We'll see what happens with NAR this year if they try to encourage the realtors to behave in a different way. They call their new initiative ACT, for accountability, culture, and training. The culture part is going to be the hardest part. Trying to get people to split $1,000 is going to be pretty hard. It's already not that much money for what you have to do. So that's the world that we're entering. Low pay, a lot of pitfalls that we can fall into at any moment by saying the wrong thing, even innocently, for $50. A lot of people just say no, but then we go back to our realtor vow and pledge, we will help all people find housing. Somebody's got to do it.
So I want to add that I personally don't deal with rentals. I feel like they are very strict on how they qualify their tenants, and their whole thing is just hard. It's easier to get a home mortgage than it is to get a rental property, to get into a rental. So I mean, I do feel bad. It stinks because they're more strict on the tenant and rental portion of real estate than it is to buy a home, which is crazy to me.
Yeah.
And they have a lot of more requirements, a lot more, I don't want pets, I don't want this, I don't want that, when in real estate, if you're buying a house, you can do whatever you want, unless you're in a condo or 55 plus, whatever, things like that. But, I mean, a lot of those rentals, I know a lot of agents that do rentals that in turn help them rent a property, help them find a home that is below what they're looking for to pay, and guide them to buy a property eventually. So I know a couple of agents that make that their career. They help the rentals, they make sure that they're on the right path to make sure that they're available to eventually get to where they are in a position where they can buy. So I know that up front is a lot of, problems and hiccups that can happen, and just the inventory in general is low, and the requirements are so high, but if these people are forever grateful if you find them a rental, especially that one that has no lead paint, that accepts children, that accepts, there's no hiccups, and they have parking, animals, things like that. Like, they'll be grateful to you, and they'll refer others, even if they're rentals, eventually they're going to call you and buy. So a lot of people do rentals.
It's huge for that. I'm going to put a listing up later this week, and the last listing that I put up for a rental in Marlboro, I got 50 plus inquiries per hour for 2 days.
Ooh, wow.
It's fantastic, and they love you. They will stay in touch with you. These are the perfect leads.
Mm-hmm.
They're great. They have family. They have friends.
And half the time, I tell people that they call me and they say, I'm looking for rental. I'm like, I don't really do rentals. But if you have all this money up front to put down on a rental, why don't we figure out if you're pre-qualified to buy a home? Like, you're already spending all this money. That's the same money you would need for a down payment. Why not look into getting pre-approved? So it's a good lead to kind of steer them to buy. And if they're not ready to buy, then you do your homework to find them a property to rent.
Exactly. You have to invest time, and eventually they will. We all did it. We all started off leasing, and then we got a little bit nicer apartment, and then eventually we saved enough money and bought a house. That's just the whole process. Do you want to be the agent that they remembered, got them their awesome apartment, and taught them how to get a mortgage, and then took them to see houses until they were finally able to make the move? Yes, that's where we want to be. That's the long game, and how to really work and grow and develop a relationship. And that's the best part of renting as well. When you find a home for somebody, it's just the same thrill as when you sell somebody a house and they move in and you hand them the keys. It's a great, great feeling. So that was the next segue, was to how to turn the lease and the $50 profit lead. You're getting paid $50 as opposed to paying out a lot of money for Realtor.com leads. It all depends on how you want to run your business. The next section that you work with the tenant is on, once they've made it through this whole process of working with the landlord, and we won't talk about any of the disabilities or accommodations or anything at all until after this person has been accepted by the landlord, and that is when the conversation happens. If somebody says, I'm going to need some help going up and down the stairs, we're going to need to change the railing, then we need to work carefully with the landlord to make sure that everything is done before they move in, and that the landlord understands fully how to communicate with this person in a respectful way throughout the whole process and while they live together and work together. On the lease is actually, I think these are a lot of fun to fill out. When you work in .loop, you can set it up so that the lease is basically auto-filled, and then you go back through. And what are we thinking about when we represent the landlord? We are making sure, first of all, that when we do the listing, that if a landlord says that they have separate meters for all utilities, it is a good idea to take a look at the meters and see if that is the case. Most often they do not have a separate meter for the water. And a lot of the localities won't even acknowledge a separate meter anyway when it's time to pay for the water tax. A lot of communities will only allow for 1 meter. The benefit of having a second meter, even if the locality won't accept it, is that you can actually sit down and figure out what is your water bill and what is their water bill. In Massachusetts, if the landlord does not have separate meters, the landlord must pay for the utilities. This is a great thing for Section 8 landlords, because Section 8 maxes for a town such as Marlborough are $27.33 for a 3-bedroom, and I think it's $29.55, all utilities included, for a 4-bedroom. They will get their rent paid.
Can you just explain that each town can set?
Yes, each town can set their own rates based on how much it costs to live in that town, and it changes every year. You have to keep a close eye on the Section 8 maximums. This is also helpful when you're determining with the landlord how much they think they can get for the apartment in the market. Take a look at what Section 8 is, and that will give you a good idea, and then just sort of back through it by using the CMA on the MLS, just as you would the regular home, look at the other similar rental listings. But Section 8 maximum, knowing that always is very helpful. If the landlord does not have the separate meters, the landlord has to pay for the utilities. The landlord can't come back in later and say, hey, you owe me 6 months of utilities because this is half yours. That's not the way it works in Massachusetts. And the landlord cannot evict somebody if they haven't or are unwilling to pay for utilities because they don't have a separate meter. So that needs to be clear when the lease is signed, and that's where we come in. We can add a few extra things onto the lease regarding water, such as shared laundry, that you can negotiate a fair and reasonable amount for laundry if the landlord's paying for all of the water. And you can't really negotiate anything else on the utilities or anything, it's just for shared laundry. You can add it on, but even if the tenant agrees to it, it's not going to hold up if there were a dispute. It would be something to run by a lawyer if you have anything to do with the utilities being paid by the tenant without a separate meter.
And do we have pet fees in Massachusetts?
We do not have pet fees in Massachusetts. That is illegal. Other things to watch for on the lease will be some landlords prefer to not have an official lease. They prefer to have a tenancy at will. A tenancy at will means that the landlord or the tenant can give each other 30 days notice to move out. This is used very often in an owner-occupied unit. It's basically, as it says, at will. You don't have to have a reason. You just give them the written notice that they need to move by a specific date, and it's bi-directional. Either party can do it. Any questions about the exclusive lease agreement?
Can you, that chapter right there talks about the cleanliness. Can you talk about the walkthrough with the tenants before they occupy the property?
When I do a walkthrough with the tenant, I bring my camera and I take a picture of everything, and I also will do a video before I leave, so I have a full view of everything that's in that apartment. I also make a list, and we will write down every single thing. Even if there's a nail sticking out, or if there's a piece of carpet that's a little frayed, any small little damage or repair, even no matter how minor it is, must be noted. Because at the end of the lease, when you want to move out, the tenant wants to move out, they will go back in and they will charge you for what they have to repair. And if you don't have a piece of paper that they signed from the very beginning saying that there was already damage to the carpet, you will end up buying that landlord a brand new carpet for that room. So we have to avoid that by taking meticulous notes of even the smallest amount of damage. In this room, we could take a look and see up there are some of the near the vent. Looks like it's, I don't know, something going on there. We could take a look at the paint and see if it looks like they haven't done any painting in here for a while. There's some
TV was there.
Yeah, TV's over there. We got some streaks coming down here. What's that? Seems like small potatoes, but at the end of the lease, there could be water damage back there. There could be a squirrel knocking that thing out. We don't know.
So in this 2-page handout that we did, you can show this to the camera, when we took the rental class at the MIR board, I remember one of the landlords saying that he doesn't do the walkthrough in the beginning. So if the landlord is not with you, more reason for you, when you're accompanying the tenant, to have those pictures to prove that there was already a dent in the refrigerator at the time that you rented it. It's protecting the tenant.
Yeah. It's sad that
Yes.
you get really bad landlords, so you want to be protecting your clients, because there's some slumlords out there that you don't want to deal with. And the tenant, even though it's the landlord's fault, they're going to look to you for guidance and or fault in the situation. Everything always comes back to us, so we want to make sure we cover ourselves and protect our clients in the same way.
Exactly. Has everybody here used .loop? Okay, good. Make sure that as soon as you get any rental tenant client, that you instantly go in and get everything set up in .loop, print it all out, and have it ready for your first meeting together, and start talking from the very beginning about as we talked about yesterday, about the lead paint and about all of the documents that need to be signed. And then, of course, as soon as you're going to go see a property, you're going to do your disclosure form and get that up into .loop. That's commercial and residential. Everybody who's going to be on the lease signs that thing. If they're not there at the time that they go through, then you can send it over in .loop and have them sign it and send it back to you before you go back in again.
And the cool thing about .loop is that if you go in and create a new file, they have a drop down of New Hampshire or Massachusetts rental, and all of the forms you need are just automatically there. So you don't have to go looking for the forms and what are they called or whatever. It's ready to go. You just print them and you know that these are the forms that you need.
This might be a good time for Gail, but I have a question. I started to ask before about, I had heard that if there was a person over 18, they also have to be on the credit check?
Yes, that's an adult on the lease.
An adult, okay.
And I wanted to tell you, I had an interesting situation where there was a couple, and one person was of legal age and one person was not of legal age in this couple.
Oh, everybody get that?
Did you get it?
Oh, we got that.
So the
Emancipated, of course.
no. So,
Wow.
that was an interesting scenario. The reference was to a local high school for personal reference.
Oh, wow.
And
Be very, very careful.
Yeah.
so yeah, watch out for that. This adult did not have any guardianship over the minor.
Oh.
The landlord chose not to lease to them, and it was a property that the landlord lived in as well, and they can decide who's going to live there. Worked out okay, but you have to really watch those dates, and you have to check carefully, because sometimes people are not telling the truth about their birthday when they have a personal reason.
Yeah. So get their licenses.
Yeah.
Easiest way to figure it out.
So
And then if they don't have a license, there you go.
So we're going to back up just a little bit, back up into the qualification phase, where we're trying to determine whether we can represent to the landlord that our tenant can afford to pay for this apartment. That is the only thing that we represent up to the landlord. Everything else is personal, or it is going to come up after an application has been accepted. But we must be able to qualify and show that the tenant has the ability to pay the rent and to pay for their own living expenses and their utilities. Please welcome Gail Richards.
Hi guys, we're back, and today Gail Richards, our administrative staff, is going to join us and talk a little bit about Zumper.com.
So Zumper.com is, if you, let's say you're the buyer's agent and you go to get, and somebody wants to buy a house, the first thing they do is they say, oh, how much money can they get, or can they qualify for a loan? So that's like $650 and up, if their points are $650 and up. So if their points are about 500, you want to go to Zumper and see if you can find them a rental. So, thanks, Shawna. So yeah, so Zumper.com is what LAER basically uses, or would suggest that you would use, and it's a great tool because it actually you don't have to pay for it, it's free. And then when you get a client who wants a rental, they go on, you have to,
They do all the work for you.
They do all the work for you, thank you. So basically, you go to www.zumper.com and you have to sign in and create an account. And after you create your account, you can actually send your clients to go and sign in on your account, and then they do a whole check on them for free. And the best part about that is when we were here with the attorneys and stuff, they would say, you know, you don't want to be liable for things like credit checks and saying the wrong things. So the more you can keep yourself apart from getting a third party to help you with your rentals, the better off you are legally. So with Zumper.com, you know, you're using a third party, and it takes that legal issues away from you and onto them, and it's free. So yeah, if you're a landlord and you have apartments to rent, you can put your apartments in there, and it goes out to like millions of people all across the country. If there's someone in California and they want to rent a house and you have your properties there, you know, you go to Zumper.com, you put yours in, and it's all free. So I mean, either way, it's free, and you don't have to pay for anything.
So the website is Zumper.com, Z-U-M-P-E-R.
Yeah.
That's what you're seeing here on the screen now. And it's pretty simple for the agent side. You just create a new, well, I'm logged in now, but you just create a new profile, and this is what it will look like. You could also, in order to receive, this is your dashboard, what all that looks like here. And here is where your rental applications would come in once you have sent your personal link out to your clients. So you would copy the link and send that out to someone. This is what it would look like. It would have your information on here. They could apply now directly on the site. The site itself collects the fees, so you don't have to worry about money. And they can create their own profile. So this is where they would do all their homework, give you all of the information. The third party will take care of figuring out whether or not they're worthy of being rented to, based on their income, background, all that stuff, and their credit. And then you will get the information on your dashboard. Here, we don't have anything here to show you.
I believe it actually gets emailed to you.
Yeah.
I did it today.
So you get all the information.
It just gets emailed right back to you. So.
And it's pretty simple. Properties, of course, if you're a landlord, or if you want to put your listings on here, if you're the listing agent on the rental, that's all here as well. You can get lead reports. You can use advertising for this too.
How quickly do you get it?
I don't know. I think not long. I don't think so. It's pretty quick. And it's all pretty easy and free, and it takes the hard part out of you, taking all of the information from the client. You just send them the link.
And each admin in each office knows how to use this.
They know how to use it. They know how to guide you through the basics.
Okay.
If you have any other questions on, the back end stuff, email Happy Agent and we'll figure it out for you.
Yeah.
But it's pretty straightforward,
And
simple.
you have 2 papers that we left with you, and,
Yeah.
it's real easy. I did it, so it's not hard.
Thank you.
Yeah.
Deposits. One consideration that you have to always keep in mind is whether the landlord is going to pay your commission out of one of these deposits. When you do your check request, you need to know that. If the landlord is going to have everything come in through LAER and then back out, in order to pay you, you have to make sure that you fill out the check request form, plus you have to fill out the deposit form, so that the coordinator will know how to process the checks. For deposits in Massachusetts, you can ask for first month's rent, straight up, not a deposit, just the first month's rent. You can do this before they move in. Then what you're going to get will be last month's rent, and very often a security deposit. Especially on the higher end properties, they will always ask for all three. This could be a lot of money if the average rent for a 4-bedroom in Marlborough for Section 8 max is $29.55. Multiply it by 3. Why not buy a house? Wow. Wouldn't that be a good thing to do? That's what we look at every day. Not everybody's ready to buy, but we know that we can get them there. We can ask for a charge for the key, and that's it. Only those deposits are legal in Massachusetts. The main consideration is if you're going to have it come through LAER and then you're going to get the money back to the landlord and have everybody bring the checks to you, or if you're going to have the money go straight to the landlord. If the money's going straight to the landlord, you still need to work with your COFI so that everybody understands where this money is, and that how the commission and the money that goes to LAER is going to come in. You never want to be in a situation where people are wondering, are you doing any deals on the side? And in rentals, that is a lot more common and easy to do if you are a person who's looking to cheat the system. That's not a professional way to do things. If somebody says they'll pay you $1,000 to rent out their apartment and you don't need to put it up on MLS, and they just want you to handle it without going through LAER, that's not professional. That's a for rent by owner situation. We need to handle it by being a listing agent only. We need to make sure that all money that comes to us from any client, landlord, or buyer, seller, whoever, goes through LAER. That is a pitfall that people fall into who are not ethical, and that's not what we're here for today at all. Just make sure that you work very closely with your coordinator to get the money through if there are any particular circumstances. There could be a circumstance where the landlord isn't able to pay on time. That does happen. If it happens, you talk to your broker immediately and let them know what's going on. This is not our money until it comes back to us from LAER, and LAER needs to know what's going on. Did I get everything on deposits?
I think that it's hard to understand. Let's say the landlord is offering 1 month's compensation. So 50% is going to the listing agent and 50% is going to the buyer agent. So that's what Shawna's trying to say. Be careful to explain to your COFI how that money gets handled, that we have to pay out the co-broke.
For easier, to make it easier, just have them go directly to LAER. Just have LAER deal with it all. That way there's no question on where the money is. Just have it sent directly to LAER.
And if the COFI recommends that you do it in a different way, which they will sometimes, then you follow their lead.
Yeah.
And it works out perfectly that way. If we try to fit things in that won't fit, it will haunt you. It will cost you a lot of time down the road trying to get things cleared out, lots of emails back and forth. Best to work directly with the COFI up front. The money can move slightly differently because we don't have a formal closing as we do with a home, but we have the move-in date. Sometimes the first month's rent will be paid on the date of the move-in, plus the security deposit, and the last month's rent were paid before. And then there's another form that we have to get once all the deposits and everything run through, which is to make sure that the deposits are deposited correctly into an account that the landlord creates and puts in the name of the tenant, or has a name of one account that they work out all on their own. We don't have to advise them on this part. They can work with the bank on this. And what I do is we have a form on .loop that shows what the account is. I have them fill it out and send me a copy. That way, a year or 2 years or 3 years or 5 years from now, if there are any questions about whether the landlord has paid interest out on that account, or whether the the money has been increased over the years as the rent was increased. Everything is in dot loop. That is the way to go. Keep it there.
Super. Thank you very much, Shawna. It was great to learn all about rentals.
Oh, great. Thank you all very much. Email me anytime.
Thank you.